Good morning, all. Before we begin, or as we begin, I need to alert you to the fact that you have a choice to make right at the very beginning of our time together. You can choose to sit there and receive a lecture, which I encourage you not to do, or we can have a conversation. I would encourage you, not only during my presentation, but at any point during the time today, you've got a question, you've got a comment, ask it. Now, sometimes I'm not good at picking out hands that are just static. Go ahead and wave at me and I'll try to find you. I should have done this earlier, Carrie. How in the world do I work? Where did Carrie go? Carrie, how do I work this clicker? I still don't know what's wrong with fountain pens, by the way. They advanced on the quill. But at any rate, I'm going to, maybe it's this clicker?
Either one.
This is somewhat a standard part of a Bugby and Conkle seminar. Tybo doesn't know anything about technology.
Let's see if this is on. Oh.
Any questions so far? No? My goodness. Follow along in your written materials, please. Let's begin. And we're not going to get this, somebody will work on this while I'm talking, please? Okay, let's begin with the fact that we're going to be talking, the subtitle is the Torture Chamber, Discrimination, Harassment, and Retaliation. And why is it a torture chamber? Because no matter which way you move, you being the employer, no matter which way you move, you're going to face pain and suffering somehow. First thing we want to know is what's the difference between discrimination/harassment? Well, let's start with what the courts have told us is the difference. Discrimination, thank you. Discrimination in Title VII and all the other statutes prohibit discrimination, but they do not mention harassment. You will look in vain to find the word harassment in the laws that govern the employment relationship, and you will not find it. So what are we doing here? Well, let's start with discrimination. And all it means is that it is a different treatment of apparently similarly situated persons. In our part of the country, in Ohio, and the region covered by the Sixth Circuit Federal Court of Appeals, one step below the United States Supreme Court, they have told us that what that means is we want to look at a couple of things, not the least of which is, do these people who we are comparing, claiming them to be similarly situated, do they have common supervision? Because if Bob is a supervisor over here, and I can't move very far away from my microphone, can I? And Sally is the supervisor over here, those folks are probably not similarly situated because of the difference in supervision. And it's my experience that employers tend to run right past that difference. Don't run past it. It is a critical difference to keep in mind. The second thing about similarly situated is the job. We got somebody over here in accounting, and we got somebody over here in maintenance. They are not similarly situated. We might have a woman of color over here, and a Muslim man over here, and a Caucasian president of the company. But we do not have people who are similarly situated because of the differences in their job responsibilities. That is a critical difference to remember. So, since harassment is not defined, what's it doing in our discussion? Well, that's because we haven't really paid attention to an old United States Supreme Court case that said harassment is just a kind of or a type of discrimination. So when a law prohibits discrimination, guess what? It also, by definition, prohibits harassment. There are two kinds of harassment, and I think by now people are fairly conversant with the fact that the harassment law has grown up in the context of sexual harassment. And there are two kinds of harassment. Kind one, quid pro quo. Anybody here burdened as I was by taking Latin in high school? Carl, all right, you folks are really burdened having to deal with Carl and me. I know it permanently scarred me. It burdened me with the fact that words mean something. Quid pro quo in English would be this for that. If you don't, put out, you're going to get fired. this for that. We don't see that quite as often as we once did because I think it's finally sunk through the somewhat thick skulls of people. That's not only is that not lawful, that's just not right. So we've instead turned our focus to harassment. To the hostile environment form of harassment. And there are 4 distinct elements. They're not going to be on the screen, so you're going to have to pay a little bit of attention here. Thing 1 is that it has to be the behavior that we're claiming constitutes hostile environment has to be unwelcomed. And boy, is there room for mischief in that word right there. People participate or not. They tolerate it or not. And sometimes the line between what is welcomed and what is tolerated gets blurred. But the first thing about a hostile environment attack is that the behavior that's complained of must be unwelcomed. The next thing is it must be based on someone's protected status. Gender, race, religion, one of those, you probably HR folks can just rattle it off as fast as I can, the litany of protected statuses under Title VII. The third element is another place where we can get into a lot of mischief, and that is that the behavior that is unwelcomed based on someone's protected status must be so severe. That's fine, I'll enjoy a little music background. I ain't dancing, but I enjoy music background. The behavior must be so severe as to affect someone's terms and conditions of employment. And now we start talking about, which one do I go with?
Forward, back, and then top button's lazy.
Cool. Just clop it right in there. All right. I was mobile for a moment. I probably will become mobile again. No, I'm good. I'm good. Can you hear me without my mic? Of course you can. But I'm going to stay at the mic anyway. I was somewhere. Sufficiently severe. And that is where we can get into a lot of comments, a lot of discussions, because some people have thin skin, some people have thick skin, and the sufficiently severe aspect is, was it sufficiently severe as to this person? So when you got a person walking around with thick skin, they might be putting up with stuff that the person right next to them with thin skin is not putting up with. And so welcome to the torture chamber. The final element is that the behavior has to be conducted by a particular person, either a supervisor or anyone else, including customers. Let me say that again, including customers, including the UPS guy, including the common carrier truck driver. Is there any confusion about what any means? Any person, if the employer is aware of it and fails to take immediate and effective action. Immediate, ineffective action don't work. Delayed, effective action don't work. It must be immediate and effective to avoid liability under the hostile environment. Because we now know that harassment is simply a type of discrimination, we also know that it happens in a lot of places other than sexual harassment. I've listed here on the screen and in your book simply the most common forms of protected status: race, sex, age, disability, religion, veterans status. There are others, but enough is enough to point out to you that harassment because someone's a veteran, harassment because somebody is an atheist, harassment because somebody is transgendered is discrimination, and you're going to have a problem with it. Now, I will admit that as a matter of statistics, as a matter of what do we see more often than anything else, we see sex and race harassment more than we see anything else, but that doesn't mean the others don't exist. It means that there are no plaintiff's lawyers who have yet listened to my lecture. I'm sorry that I'm lecturing, but you're not participating. Let's go through some examples of how this can happen. And my favorite, because it's becoming a big issue. The EEOC has identified this as one of its target issues this year. Yes, the Donald Trump EEOC has identified this as one of their target issues this year. Prayer meetings at work. They can be either led by a supervisor or they can be led by co-employees, just a group of people getting together at the lunch hour. And the problem here, the inherent problem here, is we have these competing issues. On the one side is the person who claims a feeling of being ostracized or set aside or somehow or other demeaned because they do not participate. They choose not to participate, and they sense judgment coming their way because they were not, because they chose not to participate. The other, and that is played off against the employer's duty, and in religion's case, to accommodate a person with religious needs. I'm not asking for a raise of hands, but in your own mind, are you aware of how often a practicing Muslim must pray every day? There's the number. I believe, but I can't testify to this, that it's not just that number, but it's at certain times. And so what the EEOC is doing, and currently they've got 6, maybe they've got 5 or 6 cases pending throughout the United States challenging an employer who says, I cannot have a part of my workforce who takes a break at 8:30 to 8:45, 10:45 to 11, on down. 5 15-minute breaks. One of those cases, by the way, also says in this particular sect of the faith, 15 minutes ain't enough. It depends from moment to moment on the way Allah is moving in the spirit of the prayers at the meeting. And so what might be 10 minutes yesterday could be 20 minutes today. And the employer in that case said, I can't accommodate that. I need to have you at work on a somewhat predictable basis. And the commission said, you have failed to accommodate a person's sincerely held religious beliefs. You have violated the law. Here's a lawsuit. I don't know where that's going to come out, but it's out there pending. And if you are thinking, I've got the solution to this problem, Tybo, I will simply not hire a Muslim. Well, then you know already you got a problem there. If you're not hiring because of, welcome to the torture chamber. Some other example. What'd I push? Well, move up then. Come on. You think it's the air. I can't. Joe, can you hear me? I was a yes or no question. I didn't need an opinion. I just yes or no. I will do my level best to do better. Is this better? Now, how's the front row doing? God, it sounds like I'm yelling at you. We're going on to other examples. And this is where we get into the workplace banter. Oh, don't take it so seriously. We're just kidding. We're just joking. What's that you're wearing on your head? A diaper? Is that national origin discrimination? Depends on who you say it to. Depends on what the context is. Depending upon how thin or thick their skin is, welcome to the torture chamber. I take these a little personally because I have a little more gray hair today than I did yesterday, but not quite as much as I'll have tomorrow. Hey, he's a charter member of the Over the Hill gang. Hey, old timer, how goes it? These, by the way, are taken from the files of Bugbee and These are not made up. These are not made up. These are real cases. Now, some of them have got some years on them, but these are not made up. These actually happen in the workplace. Now, you're all stunned by that, aren't you? I mean, none of this ever happens in your workplace. Is that correct? Good. We got a room full of honest people. You heard about disability harassment? Here comes Gimpy with the hitch in his giddy up. Somebody's got a bad leg. They got a bad hip. They may have left part of their hip in Iran or Iraq, or in Vietnam, or any one of a number of other incidents could have happened. They could have just had a bad car accident, and now they got an inseam of 30 inches on their left leg and an inseam of 34 inches on their right leg, and they're alive, but they're disabled. And they may or may not have thin skin. They may or may not introduce you again to the torture chamber. This is, I gotta say that on this one I had to give the speaker, after criticizing the comment, a couple of points for creativity. Religious discrimination. Hey, holy roller, don't cross me today. Originality points, no points for legality. I'm sure you can each think of other examples in your own workplace where the banter is maybe something you ought to filter out. Because I can promise you this, what begins as banter, I will call welcomed conduct. You're given as well as you're getting. You're giving it right back to them. And then comes that indeterminable point where enough is that's all. And what was once thought to be welcomed behavior becomes unwelcomed behavior, and about 10 minutes later, a complaint is filed. The lag time between when it becomes unwelcomed and when it becomes an issue for me to deal with generally is very short. Let's not get to that point at all if we can. I want to distinguish, oh, okay, I've talked about others, but there's another, you folks in HR have probably encountered this new thought of bullying. What is the difference between bullying and harassment? Well, from a legal standpoint, tremendous difference. It is not illegal to be a bully. It's not a best practice. It's not something I would encourage you to do or allow, but it is not illegal. And the difference is that bullying is not based on a protected status. This is just the person who is by nature and by inclination and by choice an SOB. Somebody who just enjoys making life miserable for other people. Sometimes without knowing it, in my judgment, mostly with knowledge. They know what they're doing and they enjoy it. Does passive aggressive mean anything to you? Now, that leaves open an issue that just recently came up in the district court in New York City, federal district court in New York City. What about the equal opportunity harasser? Somebody who treats everybody like a piece of something. Honest to goodness, I'm not making this up, and I'm not trying to cast disparaging comments towards the Roman Catholic Church, but this grows out of a parish school whose principal was a young priest who seemed to think people of color would respond best if he used the N word. Women would respond best if he used the B word. And to test that out, he used them both all the time. And eventually people said, that's enough. We're done with that. And a lawsuit was filed and it was thrown out. I don't know what will happen on appeal, but let me read to you the decision, the language of the district court. Although the main allegations can demonstrate that, I'm going to change the names here, Father Smith has made numerous crude, vulgar, insensitive, and prejudiced remarks against all types of people, and that he may not always demonstrate the morals and principles aligned with a well-respected Catholic institution, the law does not impose liability based on these allegations because he treats everyone the same. I'm not certain that that's real good law, but I am real certain that if you want to test it and find out whether it's real good law here in Ohio, have a deep checkbook. It's going to be very expensive, and I think it's going to lose. Let's move off. Why can't this thing stay up with me? Retaliation. This is the most common form of charge filed with the EEOC today. From fiscal year 2011 through 2016, all filings with the EEOC are down by 9%. Retaliation filings are up by 13%. I am persuaded that what is happening now is that people realize that as soon as I make a complaint, I clothe myself with some form of protection against any future activity by my employer against me, because now I can claim, can you hear me? Are you having a problem with this working out all right for you? Joe, there's a yes answer, all right. Now I've got the protection of having made a complaint. I can pretty much write my own ticket, and if you don't like it, you are retaliating. Now, I can't get into the minds of employees like I once thought I could, but I'm pretty confident that's what's going on. As a percentage of all charges that are filed with the EEOC, they are up 37% to 46%. Almost half of all filings are retaliation. Based on harassment are up from last year, those 5 years. I hit the wrong button again. I don't hit them long enough. There we go. Here's the chart that shows you graphically the upward incline of both retaliation and harassment charges. And all overall, I went too fast. Overall charges are down. The word's out. Retaliation and harassment works if you're an employee. What's the element of a retaliation charge? Pretty simple. You got to be engaged in some form of protected activity, and then you're subjected to an adverse employment action, and the two are somehow or other connected. Let me say that at this point, the most important thing is the time element. If on Monday you make a complaint, and on Wednesday you're fired, the time element is there. If on January 1st you make a complaint, and on the following January 1st you are fired, the time element is not there. So in other words, wait a couple of weeks. What are some of the kinds of protected activity? You oppose, you send a letter, you engage in a picket, somehow or other you indicate your opposition. You participate, you file your own charge. Here's a fun one. You support somebody else's charge. You testify on their behalf. Or you're part of an investigation, either internal or external. The external investigation is the one that's conducted by the EEOC. Internal is the one that you conduct. You HR folks, you conduct your investigation, and a witness talks to you, they are participating in protected activity. Be careful when you take action against them as your investigation unfolds that they are not a witness, they are a participant. Workers' comp proceedings are protected also. Just kind of threw that in there as a fact that workers' comp is a big part of our practice. Let's use some recent examples. This is the obvious example. You're fired. Who needs to talk about that? There are some that are a little less obvious. Case out in this California. How many of the funny cases come out of California? I don't know how many, but this funny case comes out of California. This person had sued their prior employer for race discrimination, and when they applied to this employer, somebody in the interview happened to stupidly say, "Aren't you the person who sued your prior employer?" "Yes, I did." "Oh, well, thank you very much for your application. I think we will continue." You know the blah, blah, blah words that say, "You're not getting this job." Well, they failed to hire him in retaliation for his action against another employer. This is the one that I still don't understand, but honestly, God, it's out there. This one comes from Kansas, where, let me get my facts right, the applicant's sister had been a girlfriend of the HR manager and dumped him. And the HR manager decided to take it out on the applicant because she dumped him. And he was able to make a case that because of my sister's rejection of a supervisor, I didn't get hired. If we had more time, we'd go into that one a little bit deeper. There are a lot of other examples, but the one I want to get to here is the failure to promote. Not because that's not so obvious, but because I find a lot of our culture is well represented in the comics. So let's have a comic that tells us about this. I complained about my boss 2 months ago and his HR, and has HR done anything about it? That's a fairly typical conversation you hear around the work site. And of course the answer, well, there's lots of confidential things that are happening behind the scene. Take my word for it, there's a lot that we're doing. Well, for example, and here's the answer. Well, for example, we talked about how much of a whiner you are. How many of you can track this transition? From whiner to complainer, to bad attitude, to not a team player, to some form of retaliation. You're not promoted, you're transferred, you're demoted, you're fired. And it starts with, you're a whiner. Be careful, that is a slippery slope. Oh, I'm going the wrong way. I want to get to a couple. I'm going to fast. Here we go. There's some miscellaneous items that are happening in the world of discrimination law that I think we ought to touch on. The first one gets lost by people that they don't read the same things I read. President Trump has proposed merging the EEOC with the Department of Labor. That's contained in the 2018 proposed budget. It's going to get lost, I think, in the midst of those discussions, but it's out there. It's a proposal. I don't know forward from backward. Work with me here. Some of you may be aware that the EEO-1 form was revised to include pay data so that they can determine whether there's a wage discrimination going on. That has been delayed. I've heard many people say it has been withdrawn. No. It has been delayed to March 31 for the payroll period October 1 of 17 through December 31 of 17, a 1 quarter of a year period of time. I still don't know forward from backward. The United States Supreme Court has upheld very broad powers from the Commission during investigations to issue subpoenas. Let me just say that if you're going to argue that we ought not have to produce these documents, you're probably going to lose that. They have switched the burden all the way around. If you think you shouldn't produce it, you're going to have to show that it has absolutely no possibility of pertaining to the investigation. I think that's an impossible standard to reach. Sexual orientation in the courts are having a hard time deciding what to do with this. I think Mark Barnes, but somebody else is going to speak on this in particular, but I'm just here to say to you that as we speak, the best that can be said about this is stay tuned. Now, one of the things that I enjoy the most, because it's the most difficult thing to figure out, is what happens when rights collide. Whoever's following me, Carl, I'm taking some of your time. I'm not surrendering the mic just yet. When rights collide, what happens? Turn this thing right side up. Well, it begins with what's known as the Religious Freedom Restoration Act of 1993, which itself was in response to a 1990 decision of the United States Supreme Court. A fellow who worked out in Oregon as a drug counselor was also a Native American. And as a part of his sincerely held religious practices, he smoked peyote on a regular basis and hence failed a drug test, a random drug test at work. And when he went to file for unemployment benefits, the state of Oregon denied them because, under their law, that was a for-cause discharge. And he claimed that you cannot fire me for cause for practicing my sincerely held religious beliefs. And the United States Supreme Court said, wrong, yes, they can. And a young representative from the city of New York by the name of Charles Schumer, you may have heard that name since then. He is now the Senate Majority Leader, Senator Chuck Schumer, immediately introduced the Religious this one right here, the Religious Freedom of Restoration Act that passed in the Senate 97-3. Not to be outdone, the House passed it unanimously, 435-0. And it says that government cannot, cannot substantially burden a person's exercise of religion unless there's a compelling government interest and there's no less restrictive means available. Pardon me for taking the time to set it up that way, because now it becomes today. And we see the Hobby Lobby case. And I don't know if what you think the Hobby Lobby case said, but here's what it said. Hobby Lobby is a family-owned corporation. It's not IBM. It's not AIG Insurance Group. It's a family-owned corporation. And those individuals have the benefit of the Religious Freedom Restoration Act. And it is against their sincerely held religious beliefs to provide for any form of contraception. They believe that's murder. So they wanted to be excused from the requirements of the Affordable Care Act, also known as Obamacare, from having to provide that to their employees, and went all the way to the Supreme Court. And I think you know, by a 5-4 vote, the Supreme Court said, that's right. The Religious Freedom Restoration Act allows, in this fact pattern, Hobby Lobby to be excused from that part of the Affordable Care Act. Well, there's a case now pending that raises, I think, future issues for employers, and it's the Masterpiece Cake Shop case. This is the bakery owner who refused to provide a cake to celebrate a same-sex wedding because same-sex weddings, same-sex marriages violates his sincerely held religious beliefs. This is not an employment case. This is a public accommodation case. But the words in the statutes and the principles underneath them are the same. The case so far, first off, so far the cake owner, the shop owner has lost. It's coming under Colorado law. Colorado's public accommodation laws prohibits discrimination on the basis of, among other things, gender, marital status, religion. Colorado courts have held that the baker has violated the law. Now, the baker is not using the Religious Freedom Restoration Act because some years ago the Supreme Court said that only restricts the federal government. It does not restrict state governments. So, he brought his case under the First Amendment. We hear a lot of things about the First Amendment, and we don't normally think of them as being the freedom of speech, the freedom of the press, freedom of assembly. But that's not the first freedom. There are a lot of people who call the first freedom, first, certainly in sequence, maybe in priority, these words, these are the very first words of the United States Constitution's First Amendment. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. It comes before freedom of speech, it comes before freedom of the press, it's first. And the cake baker has made their argument there. Briefing is to be done this month, decision later this year. I don't know how they're going to decide it. But if they decide it, pardon me, but I can see it coming in the form of, back to the prayer meeting. What if a particular employer says, I have no sincerely held religious beliefs in anything other than the accident of nature that created all of us here. I'm not giving anybody any time for prayers because I have a sincerely held belief too, and it's in violation of that. So when rights come colliding into one another, how do we resolve them? Stay tuned. There are 21 states that currently have their own version of the Religious Freedom Restoration Act. Ohio is not one of them. If we have anyone here with a plant or a facility in Indiana, Indiana does have that law. So you would need to be alert to that. I appreciate the fact that you sat and listened so that I could get through this. It's generally not my goal to go over the time I'm allotted, but I love this stuff and there's just too much to not say. Are there any questions? Let me rephrase that. Are there any questions that you're brave enough to ask out loud? I'm going to be around all morning. Corner me, let's chat about what's on your mind. Thank you very much.